All right, this is case number 21161275. This is Portfolio Recovery Associates LLC versus Charday Leverett. Today is the date and time set for a pretrial conference regarding this matter. Your appearance for the plaintiff here. Looking for the plaintiff on Charday, strike that on Portfolio Recovery. I'll come back to that matter. Do I have do I have Leverett, last name Leverett on the Zoom? All right, the court calls case number 21170218. This is DNF Associates LLC versus looks like Shaquille Tinsley. The matter is before the court, set on for like a general hearing in this matter. Your appearance for the plaintiff in this matter.
Good morning, Your Honor. Christopher Sosson, spelled S-O-S-S-O-N-G, appearing from Bella Law Office on behalf of the plaintiff.
Thank you, Counsel. Put your number on the record if you will, Mr. Sosson.
E59383.
All right, thank you, Counsel. Good morning to you. I'm looking now for last name Tinsley. Say something if you're on the Zoom, please.
Hi, Your Honor.
All right, good morning to you. Where are you? I'm looking for you. Say something again.
I'm right here.
You're right there in the dark, right?
Yeah.
So let me get you up here. All right, this matter is set before the court where there is, on the one hand, it looks like there's an application for default, entry of default judgment. There's also a document that was submitted to the court as defendants answering this matter. That document was submitted to the court on December the 17th. The application for default was submitted on the 20th. So it looks like there is an answer regarding this matter. Did you receive a copy of the answer in this matter, Mr. Sosson?
Yes, Your Honor, our office did.
All right, so have the parties had an opportunity to talk about whether or not there are any prospects of getting this matter resolved short of the court setting it on for further proceedings?
We have not yet this morning. I would note, however, that defendant and our office have had discussions in the past that have been unable to resolve the pending action. That being said, if the court would like the parties to speak in a breakout room this morning, I'd be more than happy to do so.
All right, I'm going to provide that opportunity, Counsel and Ms. Tinsley, particularly where this is a case that involves a claim for less than $800. And the next process involved here would be a discovery process that would take 45 days to a couple of months before court to get back to this case. So if there's a way to talk about this roughly $800 case, and I certainly want you to do that. So let's take a moment to see if that is a possibility. If not, I'll bring it back and I'll set it on the calendar, and we'll move forward accordingly. So you have priority when you come back in, but I'm going to go ahead and send you to a breakout room. At this point, you're going to get a notification for a breakout room number 1, and Counsel, you'll be receiving the same information. And let me make sure, there we go. Ms. Tinsley, here comes your notice now. And Mr. Sosson, your notice is coming. Fine. There we go. Right. All right.
There we go. Thank you, Your Honor.
All right, this is case number 07 109575. This is Asset Acceptance LLC versus Diane Smith. Matters before the court on objections to a writ of garnishment. The record should reflect that the writ of garnishment arises by virtue of the fact that there was a judgment entered by default in this matter back in 2007. That judgment was renewed in 2017. The total amount of the judgment on entry was $3,508.71. All right, your appearance for asset acceptance at this time.
Yes, I'm here. My identity was stolen.
All right, one moment, ma'am. Do I have someone from asset acceptance on this matter? All right, what is your name, ma'am?
Diane Smith, alias.
Thank you, Ms. Smith. All right, Ms. Smith, this is a judgment from back in 2017 that was renewed again in 2007, that was renewed in 2017. On your objections to the writ of garnishment, you check off that I did not create this debt, had no card. So it looks like over the years that there have been various writs of garnishment filed against your income tax return. Why is it that you're just now coming and saying that you don't know anything about this thing?
Because I just got a letter about, our first letter was about 2-3 weeks ago. The first time I got a letter.
But you never heard anything about this since 2007.
Honestly, no, I haven't.
All right. Well, ma'am, you have to. I'm just looking for the record here. All right. So your objections, ma'am, that you filed regarding this matter, you have to file something to attack the underlying judgment. What has happened here is that there is a judgment in place against you that is the basis for which the effort to seize the income tax return has been filed. Now, when you object to that, the basic kind of objection that you have there would be an objection that says, already paid it, there's a bankruptcy proceedings, or that I have an installment order. What you're doing by saying that this is not my debt is you're attacking the underlying complaint. So if you believe that the underlying judgment should not have been entered, then you have to file a motion to set that aside. That's not something that you can do with the objection to garnishment. You have to do that as a proceeding against the judgment, not against the garnishment. So the objection that you raise is not an objection that can be recognized for purposes of stopping the garnishment. What you're trying to do is set the judgment aside. And you can certainly file something as an attempt to set the judgment aside. But that's not what this proceeding is about. Or you had something to say, ma'am. I'm listening to you. You look like you froze up there, so if you.
It did.
Okay, all right, I'm listening to you, ma'am. All right, Ms. Smith. All right, Ms. Smith, are you able to hear me?
So I need to go downtown?
Yeah, you're likely gonna, if you believe that the judgment should not have been entered against you, you would have to file something like a motion to set the judgment aside. That would be what you would want to do, and then get a hearing on that. Let me ask you, this is regarding your income tax return from the state of Michigan. How much money are you expecting back, ma'am?
I don't get no more money back this year.
All right, so you're not gonna get anything from the state tax return?
Not this year, no. I got $1,200 back last year. And I got $1,200 back. No, I got $1,200 back this year already.
Oh, okay. And you already received the money?
Yes.
All right. So there's nothing that the garnishment is really moot in this case because you already got your money back. They're paid on. All right. Now, did you hit the lottery or something? Did you win some gambling money or anything?
No, no, no. I get SSI disability. I get $729 a month.
Okay. All right, well, they can't garnish that. They can only garnish, something like, a state income tax return. So it appears that there's no money to be had. But in any event, the objections would be denied, but it's not gonna have any effect on you because you've already gotten the money. And then if you want to try to get the judgment set aside, you want to file something on the second floor called like a motion to set the judgment aside, ma'am. You understand?
Yes.
All right. I wish you well, ma'am. Good day to you.
Okay, thank you very much.
All right, the court is calling case number 21155, strike that 21154-558. This is Progressive Michigan Insurance versus Erwin Harris. The matter is before the court, set off for a hearing regarding a motion to set aside the default judgment, as well as a motion for installment payments. There's also the following objections to a writ of garnishment. Your appearance for Progressive Insurance at this time.
Hi, good morning, Your Honor. Jennifer Dillo, P69855, appearing on behalf of the plaintiff.
All right, thank you, counsel, and good morning to you. I'm looking for Edwin Harris, please.
Erwin Harris, yes, sir, I'm here.
All right, thank you, Mr. Harris, and good morning to you, sir.
Morning.
All right, I see that you filed three things before the court. One relates to an objection to the writ of garnishment regarding this case. There was a judgment entered against you on the 15th of September 2021 for $16,507.03. So the garnishment looks like is regarding the state of Michigan income tax return. Is that correct, sir?
Yes, sir.
All right. Are you expecting money from the state of Michigan, sir?
No, I'm not. I haven't even filed taxes yet.
All right. But when you file, what do you typically get as a return? You usually get some money back from the state?
No, I typically don't.
Oh, all right. So I never received notice. I objected to the default because I was not in the wrong. All right, that's on the garnishment stuff. It looks like there may not be a real reason for the objection. The other issue that you raise, of course, is the motion to set aside the default judgment in this matter. And you signed off on that, but you didn't. I'm looking to see if you gave me any reason why you believe the default should be set aside. And it doesn't look like you wrote anything down. But tell me why you believe that the judgment should be set aside. So.
Well, I guess I wrote the explanation on the wrong paper, but yeah, I wasn't notified in proper time. I never knew that it was going to be a court case or anything like that. I was never notified. They never sent any documents to my house. And as far as the accident, I wasn't in the wrong in the accident.
Oh,
so.
What did you say about the accident? Say that again.
I said I wasn't at fault in the accident, the car accident. It was from 2019.
All right. So I see by looking at the file that the court allowed for alternate service in your case. That is, allowed for there to be service by alternative means with first-class mail to an address on College Street, tacking at that address, and then also certified mail with return receipt requested. They had a problem serving you, and a petition was made to allow for alternate service, and the court did allow the alternate service, and that is the basis upon which the default judgment was entered. you indicate that there was an accident and that you were not at fault in the accident. Madam Counsel, if you would address that issue, please.
Yes, Your Honor, this is an auto subrogation action where it's alleged that the defendant was involved in a car accident and did not have insurance. The police report is attached to the complaint in this matter. And the police report indicates that the defendant was cited with a hazardous action of improper passing. And it indicates that the defendant failed to yield to our insured's vehicle. Therefore, I believe the police report indicates that the defendant is in fact responsible. And in light of the fact that there was no insurance, he would be liable to the damages.
What were you the owner operator of a vehicle that was not insured at the time, sir?
No, I was not, but the insurance on the car, I have the police report right here. It was through Citizens Auto, and I guess that was some subsidiary of Progressive. It was my sister's car, but she had insurance that she had been paying for months on end.
All right. And you understand that the Michigan State traffic crash report puts you at fault in this accident. You understand?
You say that the traffic crash report?
Yeah, it puts you at fault. It says overtaking and passing. And,
But that's erroneous, Your Honor.
yeah, well,
Because I have the diagram right here and I can explain it to you exactly how it happened. Physically, that's impossible for that to have happened. The driver tried to make a right turn from the left lane. And he crashed into me and my fiance at the time. That's how we hit the wall and ended up down the street. Because if I was improperly passing, we would have both went straight, or he would have swerved to the left if I had sideswiped him like the police report says. They didn't ask us, the police officers, they didn't ask us our version of the story. They just went with his story because he's the one who called the police.
and you were there when the police arrived?
Yes.
All right, so, yeah. All right, so Madam Counsel, the defendant says that the vehicle was insured that was in the accident.
I understand that's what the defendant says. I do not have a copy of this motion, but based on what the court said, it appears that there is no proof of insurance attached. I would indicate that per information that we received from our client, the policy number cited on the police report for the defendant is not a valid policy number, and that Citizens Insurance was unable to locate a owner or driver in their system. So they were unable to locate insurance for this vehicle or for the defendant.
All right, thank you. All right, sir, you get the last word on your motion at this time.
Could you say that one more time?
I said you get the last word on your motion.
Yeah, like I said, it was my sister's car. She's a very honest person. Like it says, she has the insurance, and then on his, it says his insurance company was LA Insurance. So I don't even know why I'm being sued by Progressive. As well as, like I said, the officers, they failed to investigate on our end. And I went up to the police report several times to try to get the police report corrected, and they dismissed me every single time to the 12th precinct.
All right, thank you. All right, I've listened to the argument on the motion for the motion to set aside the default in this matter. The issues raised would have to be supported by an affidavit, which they're not in any written form, and I don't have anything conclusively to establish that that there is a demonstration of a meritorious defense in this case. Everything seems to point in the contrary direction. That may just be because of the fact that there is not a proper motion that is before the court on this issue. For that reason, I'm going to deny the motion. Mr. Harris, you do have the right to refile your motion and support it by an affidavit. Obviously, the challenges that you have here is that the court allowed service to be established by way of alternative means because of the fact that they were not able to establish where your address was. But significantly, all of the information that is controlled and contained in the court's file, together with the police report in this matter, seem to point to you being responsible for the accident. But you still have the right to file a motion to pay it properly before me, and I'll take another look at it. Today, you don't have enough to meet the burden of showing good cause and a meritorious defense. For that reason, the motion set aside the default judgment at this time is denied. And again, as I've indicated to you, you can file another motion. You need to provide additional information from what you submitted today. I don't have any documents, anything that you may be referring to. All I have is a motion to set aside, and that motion does not provide any additional information regarding the garnishment. The garnishment, you have one sentence on that. I never received notice. I object to the default because I was not the wrong person. That is not enough to establish good cause or meritorious defense. You have further things to say. You can file something information. So the motion to set aside the default is denied. That means that the default judgment remains in place. You still have the right to file a motion to try and get it set aside. It's just a motion that you filed at this point is denied. As it relates to the writ of garnishment issue, you indicate that you're not anticipating that there's going to be any refund. So the writ of garnishment regarding the state income tax return is really like a moot question. So I'm going to find the objections are invalid at this point, and if they would be released to the plaintiff. If there was some money coming and it gets released to the plaintiff, and if you're successful at getting the judgment set aside, they will have to return. They would have to return any money to you that they have acquired. And so if you get the judgment set aside, everything will start at the beginning. But at this point, the judgment remains in place, and at this point, the objections will be denied. I anticipate that with some of the things that you told me, that you will likely want to file an additional motion to set the default aside. I'll take a look at it when we do it. You need additional information because you have the burden of establishing now that there is a meritorious defense. The good cause issue, two things you have to show: good cause and meritorious defense. I know that the way that you received service was by alternate means because the court allowed that. The challenge that you have is whether or not there is a meritorious defense. Do you have a defense that would be recognized in law to this particular claim? And you raised some things. You don't want to show me that. That doesn't mean anything at this point. I told you got to file another motion. I think that you got some stuff that you might want to present, but you haven't presented enough in this document in order for me to really give you consideration on the meritorious defense part. You will have to sign something that's an affidavit showing that you have a defense to this claim. And it would have to be something that overrides the fact that there was a police report that puts you at fault, the fact that there was some statement that indicated that you were operating is not assured. You could establish that those things are not true in some kind of way. You may have enough to overcome the burden that it takes to get the judgment set aside. That's where you are at this point. My orders are, as I've indicated, you receive a copy of them, and you have the right to go forward and file something separately, differently if you want to do that, sir. All right, I wish you well. Thank you, Council. Good day to you too.
Thank you.
I'm back on the record regarding the suffix 218. This is in regard to EMF Associates versus Shay Tinsley, if you will. And counsel, if you will update me at this time, Mr. Sausage.
Thank you, Your Honor. Your Honor, I can inform the court that the parties have spoken, and after speaking, the parties have reached an agreement. And I'm prepared to place that agreement on the record.
All right, go right ahead, sir, and then I'll go to Ms. Tinsley. I see that she's back as well. All right, go right ahead, Mr. Sausage.
Thank you, Your Honor. As I've indicated, the parties have spoken and have reached an agreement, and that agreement is as follows. The parties will stipulate to a conditional dismissal of the pending action without prejudice. Further, the parties stipulate and agree that as a condition of said dismissal, the defendant shall pay to the plaintiff the total amount, Your Honor, of $877.95 payable at $40 each month, beginning April 11th of 2022 and continuing on the 11th day of each month thereafter until the total balance of $877.95 has been paid. Further, the parties stipulate and agree that if the plaintiff fails to receive payment, both parties stipulate to the automatic reinstatement of the case. Plaintiff may file an affidavit of non-compliance, and a default judgment would be entered against the defendant for the full complaint damage balance, court costs, and a statutory attorney fee, less any payments that the plaintiff had received. Those are the complete terms of the agreement, Your Honor. I can prepare and submit a proposed order consistent with those terms to the court under the 7-day notice upon confirmation of the agreement by the defendant here in open court.
Thank you. Ms. Tinsley, you've heard the terms of the agreement that will result in a stipulation for dismissal of the case and the payment of $877.95 over a period of time in monthly installments of $40 beginning on the 11th of April 2022, continuing until satisfied full, and that the parties provide as a part of the stipulation that the case may be reinstated on an affidavit saying that payments have not been made, and then judgment will enter for the amount due plus costs and attorney fees, and an action can be had upon that judgment on the reinstated case if there is a failure to meet payments. Is this a correct statement of the agreement that you entered into?
Yes.
Your Honor, may I ask just one clarification? I apologize to interrupt. Did Your Honor say $20? The agreement was for.
I believe that I said the payment is $40 per month, commencing on the 11th of April. And if that's your understanding, correct, Ms. Tinsley?
Yes.
All right.
Thank you, Your Honor.
I think we're on the same page. And Ms. Tinsley, you don't have do you have a problem with the court going ahead and signing that? If I get a document that says that has that language on it, you don't have a problem with the court signing that and making sure a copy is sent to you, correct?
No.
All right. So what I'm going to have the attorney to do is to prepare the order, and I'm going to direct him to put your initials on it. I'm going to review it, and as long as it has the language in it that has been agreed upon, I'll go ahead and sign it, and you'll get a copy of it. If for some strange reason you get a copy and it has something on there that you didn't agree to, then keep the Zoom number that you came in on today, and you call in on the Zoom number and on any day and say, Judge, something's on that order that's not there, and I'll get Mr. Sauson's office in, and we'll talk about it and get it all taken care of. Does that make sense to you?
Yes. Thank you.
All right. So, Mr. Sauson, I'm going to give you the email address so that you can email that order to the court, and then I'll get a copy sent out to Ms. Tinsley, and I'm sure your office will send a copy as well. That
Thank you.
email address is Latifah, LATIFAH.Hunter at 36districtcourt.org.
I'm sorry, could Your Honor repeat that just one more time?
No problem, sir. Latifa, that's Latifah dot Hunter, last name Hunter, at 36districtcourt.org.
All right, and I'll repeat that to the court. That's LADIFAH .Hunter at 36districtcourt.org.
You got a D where you should have a T. It's LAT.
LAT.
Latifa.
LAT, my apologies. LATIFAH .Hunter at 36districtcourt.org.
That's correct, sir.
Your Honor.
All right, thank you. Thank you, Ms. Tinsley. And I'm awaiting the order and I will get it right out to you, ma'am, once everything is signed.
Okay, thank you.
Thank you very much, Your Honor. Thank you, ma'am.
All right, the court now calls case number 21, 143538. This is Midland Credit Management versus Janice Shumpert. Shumpert, I should say. Matters before the court on the following objections to a writ of garnishment. This is regarding a judgment that was entered in this case. It looks like that judgment was entered on the 29th of April of 2021. For the sum of $2,510.59. The objection to the writ of garnishment, it seems that, well, it's not noted as to where the garnishment is or what agency. All right, your appearance for Midland Credit. All right, do I have Janice Shumpert on the Zoom? Janice Shumpert. All right. It appears that neither party has appeared on this matter, and for that reason, the objections to the writ of garnishment will be dismissed at this time. The court now calls case number 21-151050. This is Valley Hill Properties LLC versus Alicia Thomas. The matter is before the court on the following objections to a writ of garnishment regarding the Michigan Department of Treasury. The record should reflect that the judgment was entered in this matter on the 24th of May, 2021, for the total sum of $4,684.71. That judgment was entered by default. All right, your appearance for Valley Hill Properties, please.
Good morning, Your Honor. Michael Gothal's P number 48992, appearing on behalf of Valley Hills Properties LLC.
Thank you, Mr. Gothal. Good morning to you. I'm looking now for Ms. Alicia Thomas. Ms. Thomas, if you're on the Zoom, please say something at this time. Ms. Alicia Thomas. That is set on for 10 o'clock a.m. Ms. Gothal, have you spoken with Ms. Thomas today or before this hearing?
No, Your Honor, I have not. I did file a written response to her objections and mailed a copy to her on March 3rd. I have not had any response to that or heard from her otherwise.
All right, it appears that Ms. Thomas has not appeared for this hearing. Therefore, the court will deny the objections to the writ of garnishment in this matter. I'm signing the order consistent therewith and finding the objections invalid. Funds will be released to the plaintiff, and that is my order. You receive a copy of that order in the mail, sir.
Very good. Thank you, Your Honor.
Thank you. Good day to you.
You too.
court is calling case number 21-240455. This is Karen Abram, I should say, Carter versus Kenneth Rambin and Brenda Rambin. This matter is before the court after being referred for mediation regarding this matter. Your appearance for Mr. Carter, please.
William Jerzak, P73185 on behalf of Mr. Carter.
All right, good morning to you, Mr. Jerzak. I'm looking for Mr. Rambis or counsel for Mr. Rambis. If you're on this Zoom, please say something. I know that I have Mr. Brian Hill.
Mr. Hill, I did have a conversation with Mr. Hill this morning.
All right, well, let's see what's going on here. I see Mr. Rambin is present, Mr. and Mrs. Rambin, is that correct, sir?
Yes, sir.
All right, good morning.
Mr. Carter here, I believe, is under Barbara Selden, the name that's on the Zoom device.
Where is he again?
I believe I saw him on the list of participants. It's under Barbara Selden.
All right, gotcha. All right. Got it. All right, thank you, sir. Update me, Mr. Jerzak.
So last time we were here back in the beginning of January, this case was referred for mediation through the mediation tribunal. Neither of us have gotten any dates from the Mediation Tribunal Association to mediate. So, it was at the anticipation that before this date we would have mediated. And, I guess at this point, I did speak with Mr. Hill, and I'm not sure if mediation is going to be productive going forward. I mean, I would still like to mediate, but if it doesn't sound like there's going to be anything productive out of it, I think maybe just an in-person trial date would be what we would be asking for.
All right. So, in your discussions with Mr. Hill, is that about where he is with this? Do you have any idea why he's not here, or?
No, he said that he was gonna log in.
All right, well, if you have a way to reach out, maybe a text message or a email or something, let's I'll call the case back in about 5 minutes or so.
Okay, I'm gonna send a text message right now.
Thank you, sir. And Mr. Randall, we'll be right back to you, matter shortly, sir.
Thank you, Judge.
Yes, sir. I'm calling again for portfolio recovery versus Charday Leverett. That matter is set on. Excuse me. That matter is set on for a pretrial conference on today's date. Court did set a scheduling board and set it up for subsequent hearing on today's date. Do I have someone from portfolio recovery?
Gabrielle, they sent it to this one time.
All right. My understanding is that matter is in fact dismissed at this time. All right, this is case number 21-24-0837. This is Vermeil Fleming versus 3K Auto Service. This is an appeal from a determination of magistrate in this court on an appeal of a noble as an appeal of right from the determination of the small claims division of this court. Do I have Vermeil Fleming on this Zoom? Say something if you hear. Vermeil Fleming, say something if you're here. Matter set for 9:30. Do I have someone from 3K Auto Service?
Yes, Your Honor, present.
All right, what's your name, sir?
Raphael Wright.
All right, thank you, Mr. Wright. Mr. Wright, is 3K a corporation?
No, it's LLC.
All right, thank you, sir. So have you spoken with Vermeil Fleming?
No, Your Honor, we had a small claims matter, and I'm losing the date. But it was decided then that there was a.
Let me stop you on that. If that's got something to do with this case, I don't care to know what the decision was. This person, this person appealed from whatever that determination is. And have you talked with that person since the last hearing that you had?
No communication, Your Honor.
All right, in as much as it appears that Mr. Fleming has not appeared for his claim of appeal on this matter, the claim of appeal will be denied at this time. The defendant has not appeared. So whatever decision was made by the magistrate, that decision remains in place because the appeal is denied. Right. Good day to you, sir.
Thank you. Have a good day.
Just one moment, everyone. All right, we're back on the record regarding the subjects 455 Abram Carter versus Kenneth and Brenda Raymond. The matter is before the court after a return from the issuance of an order regarding mediation. Seems to be that the parties did not have attitudes back to be mediated. And Mr. Jerzak has entered his appearance for the plaintiff. Your appearance for this matter.
Your Honor, Ryan Hill, on behalf of the defendants in this matter.
Thank you, Mr. Hill. You win at having the loudest advice that I've had this morning. So I don't know what's yours is really, really loud. All right, so what's going on here? Mr. Jerzak did tell me that that there was a failure and that no mediation actually took place. I'm just trying to figure out the way forward from here. What do you need the court to do, or is there some mediation that you can have to try and get this to some type of
Judge, I think I can answer that question. So after we left, and I've spoken to Will already, after we left the court the last time, my office did reach out to the mediation tribunal, telling them that we've been ordered a mediation. We never received anything back from them. However, I will say this, Will and I did speak this morning, and can you hear me okay, Judge? Okay, what I don't want to do is waste the court's time or the mediation time. I think we both agree that mediation may be futile after we've both had an opportunity to kind of prepare for mediation or trial. I think what the parties are going to agree to, if the court would allow us to pick a trial date that we can do it in person, this will probably take Judge Will, 2 hours max, you think?
Yeah, I've got exhibits to present. I've got a couple of witnesses, but I've got exhibits mainly in the form of photographs and things like that to present.
So would the court be inclined to just set up for a bench trial in person? And again, this isn't a medical malpractice case, Judge. This is just damages after someone vacated a tenancy.
Sounds good to me. We will set it up. How soon do you want to do this?
I'm ready whenever. Just today, I didn't think it would be appropriate just because the court did order mediation. I didn't know what the court was going to do with that, but there's certain dates I'm not available, but if the court wants to just pick some dates.
I would say, yeah, about maybe 30 days out would be fine.
30 days or so out.
The one late for 11.
You guys want to come in and maybe an afternoon and do it?
I couldn't hear you, Judge.
Yeah, you want to come in on an afternoon and get this done?
Yeah, that'd be great. I am gone from April 6th to the 11th, just to let the court be aware.
Okay, got you.
We do 13th.
The 13th of April,
Yes, I could do that.
or 13/22. I'm gonna go ahead and set it for 1:30.
Okay, and that's in person, correct?
That is in person.
Okay. So I believe that would be easier to do with the exhibits and things like that than trying to do that on Zoom.
All right, we'll see you at that time. We're, go ahead and set it up. You'll get a notice in the mail as well. It's 4/13/22 at 1:30 a.m.
Thank you, Judge.
Thank you.
Okay, good. This is Abram Carter. Can you hear us? This is Abram Carter. I wanted to be sure that the judge recognized that he was online.
Yeah, your attorney already indicated that.
Okay, could you see us? Just wanted to be sure.
I see you.
All right, nice to see you
I've seen the
too.
gentleman there for a long time. He's been
Did you?
sitting there.
Good. Okay.
I don't know why you were somewhere in the background baking cookies or something, but
I love cookies. So nice. Just wanting to be sure. You know how it goes in court.
Thank
Have a
you,
good
guys.
day, everyone. Thank you.
Thank you, Judge. Thank you, Ron.
all right, good day, good day.